morning. If we get reconvened, that'd be great. I think our symposium director has been very strict, wanting us to keep on task, and so we will do that. I will not disappoint, hopefully. Also, the word is that I'm to keep introductions brief. So this is the 11:15 panel, assessing reforms in legal education, what has and hasn't worked well. I am David Mitchell, the moderator. I have a very insignificant role. I will hold up the time signs for our panelists, who I know already have been cautioned to keep their remarks within their allotted time limit as well. In any event, we have Judith Wegner, Dean Judith Wegner, will be our first panelist who will be speaking, Professor Dave Moss. I said Ross for some reason, I don't really know why. And Professor Fines will also be speaking as well. So, turn it over to them.
This is a great panel. Thanks to John for all the work and all the other folks, the students who've taken on the obligation to help get all this in print, all the wise things we're going to say. I know, based on having seen those ahead of me, that it's going to be taller to speak fast and get it in 15 minutes. So here we go. I'm delighted to be in this part of the panel. The overall theme, as you know, is overcoming barriers, and we've seen from Lisa about possibilities. We've seen from the prior panel things about necessities. I want to talk a little bit about methodology, how we get through these barriers. There's possibilities in how one might respond to this notion of trying to assess what's been going on, one of which is to talk to you about what others have been doing. Lisa did that to some degree. We could also talk about best practices and implementation, but I'm not going to do either of those things. I just put that in front of you as a road not taken. Instead, I think what's important is to recognize that best practices and achievement depends on the context in which you're making curricular decisions, and instead what I'm going to try to do really in honor of the spirit of Missouri, insofar as you really understand dispute resolution, is to present some thoughts about process and how is it, why are we talking today about barriers, why are there barriers, and how do we negotiate those barriers. I'm going to argue that we need to therefore focus on the process of change, and that's something I think a lot of law schools are trying to bring about change, but we don't necessarily share tips on how we go about getting there. So I'm going to use a metaphor having to do with barriers, and indeed I'm going to mention some things about architecture, which I've had some involvement with lately, to think about cornerstones and curb cuts as ways to get through some of the challenges related to barriers. Three sources of insight very briefly. You've heard from others about the Carnegie Foundation work. That really reflects work we did over an intensive 2-year period, visiting 16 law schools, distributed regionally, 2 of which were in Canada. So we have a lot of insight about what is happening in schools before the report came out. And I'd have to say, even after the report has come out, if we went back to those same schools, I think we would see still differences that are really appropriate based on the character of their student bodies and what they're trying to do. I'm going to give some examples from a 2-year effort ongoing that we made at UNC to change our own curriculum. And then I'm going to talk a little bit about architecture. I've had the privilege in the last few years to be the public director on the board of the Association of Collegiate Schools of Architecture, which is very similar to the AALS, only this is folks working with architecture. So I've thought a lot about the insights one draws from architecture and want to offer some of that to you as well. So here's my images to think about. They're deliberately chosen so that you really think about what is a cornerstone, what is the function that plays, as well as that may not be the most beautiful curb cut, but the point of curb cuts, which are really to cut through barriers. Cornerstones are important because we have cornerstones. We may not even realize the hidden assumptions on which our edifices are built, and may need to think about what are the new cornerstones if we're trying to erect some changes. What I mean by cornerstones really is those foundational principles that either help us or hurt us in moving toward curriculum reform. And when I talk about curb cuts, I'm really talking about practicalities in trying to establish momentum. So here we go. First, as to cornerstones, I think it's important to realize there has to be an imperative for curricular change. If you don't have some imperative, you can talk about it, but you're probably not going to get there. We've heard a good deal of Lisa's comments this morning about the force of the job changes and the market changes, the application pool. things of that sort. Many reasons to have external forces motivating us to change, but internal motivation, I think it's really important, even more so, because if you don't have internal motivation that's really rooted in a desire, both by the students, faculty, alumni, to make something better for their own reasons, it's much harder to have a genuine, successful result. So if you think about it, this is something Barb, I know, could talk at length to us about the power of internal motivation as opposed to being forced from the outside. I think you need to really think about what the internal motivation is if you're really going to try to move through these barriers. Not all problems are created equal. I've written at much length in a piece in Rutgers about wicked problems, which is actually a phrase used by folks at a Berkeley architecture program to talk about the nature of certain problems that are not easily defined, that keep kind of slipping through your hands as you work on them. Instances in which there's no true or false answer. I think it's really interesting to realize that a design issue is a typical wicked problem, and that if you're going to take on that kind of a problem and try to find ways through it, you're going to have to put aside some of your assumptions that we really grind in everybody in law school about proceeding stepwise in an analytical way, because if you do that, you're going to run into disagreements without even knowing what the source of the disagreements are, since people often see the problem differently. I also would commend to you, I don't have time to talk about it, but a very recent book called Thinking Fast and Slow by Daniel Kahneman that is quite interesting, because he talks about the different dimensions of the brain process and how that affects judgment, practical judgment, judgments about change, a whole lot of different things. And I think his point is there's part of our brain systems that are intuitive, that handle certain tasks. There's others that are rational, that we try to grind down to get with greater effort at certain kinds of tasks. And we really need to be aware both those things are at work when we're dealing with a major problem. So think about how you define the problem. Next thing, thinking globally, acting locally, is something that I think most people have heard that phrase before. The idea here, if you're exploring curriculum reform, is one of the roads that I didn't take, namely to try to tell you all about all the changes anybody has made in any place. But the risks of that are a poor fit. If you pull somebody else's curriculum off their shelf and try to put it on your shelf, it may not fit well. So look at that Cornerstone picture if you haven't already attended to it. It's pretty complicated, right, to find a cornerstone, to build around it, to see that it's providing this substantial support for the whole enterprise. And if you think that you could fill all those other stones around it just randomly, you're mistaken, because you really have to have some close fit of what the supporting parts are with the foundational notions. So I just say to you, when you think globally, be aware that you're bringing to bear mental models. Many times faculty members are bringing the previously imprinted mental model that they had when they were trained in their own days as law students. Moreover, there's some really interesting writing in the education literature about how higher ed institutions have a dynamic of pursuing prestige, whereby they try to do what people up the food chain have done, and what that ultimately does often is to lead to more expense, to lead to not very suitable reasonable decisions related to your own population, and it's really kind of a quest for something that's an illusory Eden that faculty are drawn back to because they think there's a prestige point out there that they all want to be associated with, but that often neglects the local realities that have to be attended. So again, thinking back to that cornerstone, it's very important to realize you have to pay attention to the fit and the context when you're engaged in this kind of change. In addition, I think leadership is important. Having a dean like Lisa or other deans that have brought about stimulus for change in their institutions is an important part of the mix, but ultimately you have to realize that the cornerstone is more than any individual piece. It's really a fundamental building block that needs to be thought of in terms of the collective effort. And you really need to recognize that if you're going to take on this kind of an enterprise, you have to listen and learn, and that takes some time. So I wanted to just give you this image of Newgrange in Ireland. I don't know if any of you had the pleasure to be there, but it's quite a remarkable place. The community that built that edifice, which is really remarkable, did it over several generations by going on the river, bringing quartz back to make that ring, and they did it in part using some dry stone construction methods that were really remarkable for this time, let alone many, many years back. And they did it with beauty, as you can see there, too, and they did it in a way that allowed them to have the way the sun hit some of the openings in that tomb site really illuminate on solstice periods in honor of the people who were dead that they were honoring there. So you need to recognize if you're really going to change your whole edifice, if you're really going to try to build towards something important, it may well take some time, and it really should have some beauty as a result of it. Finally, in terms of cornerstones, I think it's important to think about testing and assessing your assumptions and being aware exactly of what is your cornerstone effort. One of the good things about Carnegie that people probably have not heard enough about is during the Schulman's leadership period there, they worked on really trying to define the scholarship of teaching and learning and seeding with expertise around the country people who could understand about defining an issue that they really were interested in. For example, somebody in chemistry from Notre Dame said, why is it that so many women and people of color don't go through the chemistry course gateway and go on to be chemistry majors? So by asking that question, he then developed a system of using teaching assistants in different ways, and they found that they really had a much different output at the end of the day. So it's really important to be thinking about posing questions in a disciplined way, trying to learn from that. As Lisa said this morning, learning outcomes and accreditation are going to be coming at us seriously. I could probably spend an hour on that, I won't, but bear in mind that that is really something that is telling us we have to think about what we're trying to do. Why did we pick this shape of Cornerstone? What does it mean to pick that shape, and how are you going to work with it once you've got it in place? So that's kind of the upshot there. Quick summary on cornerstones. Moving to curb cuts. Practical momentum is what I think about in terms of curb cuts. First of which is thinking about imperatives and intersections. There's a curb cut, as you may know, the requirements for accessibility really came out of the Rehabilitation Act of 1973, adopted by Congress, and a lot of people complained about the cost of moving to have curb cuts, to have kneeling buses, to have ramps, to have captioning on public television, things of that sort. But when you really get down to it, if you look at what the imperatives are, see where they intersect, they may be coming in ways that seem at odds, like arranging for pedestrian traffic in a very heavily transportation-intensive arena. But what they give you a chance to think about is where the blockages are and where the potential for flow is. Now people would say with curb cuts, that's good not only for people in wheelchairs, but for any law student that's trying to lug stuff with them. They may have a rolling case that they take with them. For people with strollers, a lot of different reasons there, and that you really can see how what seems to be a blockage is an opportunity to pay attention to flow. So to give a brief example from UNC, we were trying to work on changing both our first-year curriculum and our advanced curriculum. At one point, we had faculty who wanted to reduce first-year substantive courses to 4 hours from the 5-hour version that had existed previously. They weren't sure, however, what they were going to do to replace that. Some people didn't want to give up the hours, but we also saw we wanted to enhance our liberal writing program. So by seeing those two things come up against each other, we ended up with reducing first-year courses to 4 hours and raising criminal law, so it too was 4 hours to make it more interchangeable, as well as expanding our liberal writing program to 6 hours with full-time instructors. Thinking about another curb cut, these are kind of ways through the morass. Need to experience as a reality the possibilities of change and to really understand where people are coming from, what their points of resistance would be. As I think many of you, if you've thought about curriculum reform, realize you can look at other schools, bring in experts, you can look at student assessments like the Law School Survey of Student Engagement, talk to alumni, do surveys of the faculty and so forth, discuss among your colleagues by substantive field. But I think the one thing that was most important to our process was we started a series of teaching roundtables on different topics, such as dealing with large courses and making them engaging, dealing with race and gender and sexual orientation in the classroom, how we taught seminars, and what we found was we built a lot of commonality and shared appreciation for each other by having that conversation at the same time we were talking about curriculum reforms that kind of took down barriers as a result. Third curve cut is realize you have to proceed in stages. Our process, we had what we thought was a pretty good set of proposals after 1 year of work. We presented to the faculty, thought we had agreement in principle, but we also then hired a bunch of new people that year. So by the following fall, people said, well, I wasn't here, I'm not sure I agree with that. The committee, happily, we had the wisdom to say, we'll take the people as they come and have to realize that. And at the end of the day, we had more focused discussions, really zoned in on the question of first-year changes that I just illustrated and upper division changes, particularly by developing a program called Transition into Practice that in some ways resembles Lisa's capstones, but is slightly different, as I'll try to speak to in a moment. Construction strategies. This is important as a pragmatic point. I'm down to 0 minutes. I'll be very quick here. The idea with transition into practice was to say to faculty members, at your option, think about, instead of teaching a class at seminar, think about teaching something that has an applied dimension. So it could be advanced bankruptcy, it could be a co-taught advanced family law offering with a practitioner partner, but the point of it is by shifting what we were already doing and making it optional to draw people into this approach, we were able to substantially enhance the array of practical experiential offerings compared to what we had before with virtually no substantial added costs. Incentives work better than mandates, so in order to achieve that, we used modest summer grants. We developed a collective repertoire so that you weren't committing to have to teach that course every year, but it went into a collective goal of having more courses across a variety of fields. So that's my summary. My bottom line is we can get there if we try. Thank you.
Well, good morning.
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 Can we just advance?
You'll need to exit out of that. No,
Right.
not yours.
Super, thanks. I most certainly bring more questions than answers to the Legal Education Academy, but I am from the East Coast. I'm from New York. I'm a tenured professor, so not having answers absolutely not going to get in the way of me telling you what I think you should do. And so understand that as an outsider, and I am very much an outsider and at risk of offending everyone, literally everyone in the room, I've not been to law school, and I have no interest in going to law school. But I've noticed a few things which are very, very interesting to me. You seem very much tethered to tradition, which is marvelous at one level. And yet when we look at the cognitive revolution, our understandings of how people have learned, and we look at what motivates adults to learn, and when we look at technology, and when we look at globalization, et cetera, et cetera, et cetera, we must begin to question this tethering to tradition in ways that may not make sense. And I think John and others previously, we painted a picture here today of a rapidly changing landscape. And we were discussing last night at dinner whether there's going to be a snapback, whether this is sort of the 08 phenomenon. And I think the consensus was there's not going to be a snapback, and we're in a new era. And perhaps that could be said at any time, but it's important to understand. And at the same time, we saw this morning with our keynote in Dayton, there are wonderful pockets of excellence here in the Legal Academy. But what appears to be yet developed, from my perspective, is these pockets of excellence. There's not a lot of coalescence or synergy there. If we look individually, we can see bits and pieces. What's the mechanism to pull those together, to transform, to get us to where we need to be to meet our new realities? I'm a curriculum theorist. maybe the first curriculum theorist that you've ever seen. We don't typically wear suits. So don't look for us dressed like this typically, but special occasion today. I spent my time thinking about power and privilege and underlying elements of curriculum and what's really embedded in there when students and teachers interact in context. It is and has been described as a complicated conversation, a wonderful conversation, but not always face-to-face. Things happen underneath, which are very, very important. We deal with such things as epistemology and philosophy. Now on the bottom here, when folks think about curriculum, I think folks have a tendency to think about syllabi and subject matter and quizzes and tests. I don't ignore that. Those are how the curriculum play out day to day. Absolutely very important. But what goes into all that stuff? And just some representative questions. You know, what is knowledge? You know, that's not a yes or no. We don't come to an answer on that question. It's a constant dialogue, questioning what goes on there, so that when things actually play out in the teaching of our subject matter, we have some deep and meaningful perspectives on what that is all about. Curriculum mapping, to me, is an excellent way to begin to understand what happens in the curriculum theory realm, and yet is also very practical in that day-to-day. 10 years ago, if you were at law school and you were curriculum mapping, I'm going to say you were ahead of the curve. Maybe that was even 5 years ago. I'm not certain. I would say today, if you're not in the process of curriculum mapping, you are behind the curve. Absolutely. You're looking for a way to get started in this complicated conversation, curriculum mapping. It is a process. Curriculum mapping is a process. Yes, at the end of the process, you will have a curriculum map, which includes all of these elements that I have. You will understand your scope and sequence, and you will see which courses go where, and you can identify gaps, and you can align those to the bar exam, blah, 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 blah. And my co-author and I, happens to be my sister in this particular case, very strange circumstance, story for another day. Work that we did with her in her law school was about this difference between the intended versus the delivered curriculum. So just as a little heads up, if you're going to curriculum map, and you've got multiple sections going, taught by multiple people, there's this idea of like, well, this is what we intend, but we actually looked at what was being taught in various sections of ostensibly the same course, given for the same credit. We found the delivered and intended curriculum looking very, very different. But it's a process that can begin to uncover elements of your curriculum and leave you in a position to have that complicated conversation, that ongoing and complicated conversation. So, heads up, when you initiate curriculum mapping, don't give yourself an end date. You'll generate products along the way, but it is ideally a process that will go on and on and on. Not unique. That's one of the good news I really wanted to share. Across higher ed, many of us are facing the same challenges, this idea of academic aims and professional outcomes. And these are some things I suspect will show in your curriculum map. And you've got different terminology than we might in education, that School of Engineering might, that School of Nursing might, etc. But basically, we're all facing this tension of, you know, we've got this long history of what counts as being learned and smart. We've got this knowledge base, and yet things have moved, and we know that nurses and doctors and teachers and lawyers, it's more than this traditional knowledge, this I was going to say static, but that's not really true in any field, is it? It's an evolving knowledge base, and yet there are skills that go along with that, and we share that, and we can learn from that. And I'm thinking, a future symposium, I'm not sure if that happens here somewhere, but wouldn't it be interesting to get together the teacher educators and the legal ed academy and the doctors and the engineers and the nurses? Wouldn't it be interesting to share this tension that we seem to have in terms of academic aims and professional outcomes? You call this practice ready. Again, other fields have the same type of notions. We know that what was once sufficient in terms of preparation is no longer so. And so what does it mean to be practice ready? What does it mean to think and function as a lawyer? These tensions of skills that I need to know. And it was a wonderful, wonderful sort of the heads and the hands and the heart. And yet we function as a single system, so we know things can function together. Well, But what does that really mean, and how do we go about achieving those aims or outcomes? I think it's interesting that we're sort of, and I forget which presentation it was this morning, about this idea that, maybe it was the keynote again, I think, where the ABA is considering outcomes. I think you've got outcomes. I just think we need to make them more explicit and bring them up to the surface. And it's that implicit-explicit tension, which I think is what we're talking about. Very quickly, there's some interesting literature on what it is to be professional. And if you read some of these characteristics, non-standardized complex work, right, enforced standards by peers, this describes you to a T. Absolutely. Some earlier research putting other professions, not you, in this category of semi-professional. This sometimes is used to describe nurses and teachers and such, for example. But as we go back, if I can, yes, if we go back, you are on such a solid ground here. We look to you, and we, oh, God, they have it easy over there in the law school and what they do. What's the problem? That's what we're wondering. Most of us are operating in a different realm altogether in terms of semi-professional. We're trying to claim territory that, from our perspective, we think you own. So that's my way of saying you're really there, and I think the kind of reforms that you're considering in terms of the skills and the writing, which I think some folks somehow view as sort of somehow less than that traditional legal stature. I wouldn't be concerned with that. I think you are in many ways, the quintessential in terms of professional. And by bringing in this broader, more holistic ideas, you're really not at risk at losing that. It really is about power and privilege, right? In terms of these academic aims and these professional outcomes. And I don't even know what word to use here. Certain aspects of law schools are seen as more, and I put in rigorous, but I wasn't sure if scholarly or academic, right? We recognize this. But by bringing in others doesn't mean we diminish what's still there. And we said that this morning. Like, we want to keep that first year study, right? What it is, and then let's think about how to build on that. So it's not this either or. We're not wiping the slate clean here as we reform. We're talking about building on strengths. The hidden curriculum. Building on these strengths, mapping our curriculum, thinking about these implicit and explicit messages of power and privilege. It really is understanding what you want to value in terms of your graduates and what your profession absolutely values. And it's a matter of looking at your curriculum, thank you, in ways that I would argue are more holistic than in ways that you are doing now. The thing with this notion of a hidden curriculum, that is these holistic of ideas, what really is to be a lawyer, and really facing those and understanding those as law schools and including those as part of your professional practice, right? The thing is that most students don't see aspects of what I'm going to describe as a hidden curriculum at first. Faculty, we know what you're headed through in terms of your legal education. They've been there. And they have a perspective. Students don't always have that perspective. Sometimes not all faculty even have that perspective. But they begin to pick up messages. They see which profs are teaching which courses, which ones are considered foundational, what's the one course that nobody ever gets a great grade in. So your students start to make value judgments about what matters in the hidden curriculum. Wonderful quote by the individual who actually coined this notion, where they describe schooling as not merely sort of what happens in terms of the formal teaching, but the hidden curriculum as a socialization process. Again, I'm building an argument that it's holistic. All of the messages are being received by our students, whether we intend them to be or not. And so I promised some questions, and I came with more questions than answers. Let's just go a few of those. In what ways are we explicitly and implicitly communicating to our students what we really value, and are these messages consistent across our program? Again, not a product-oriented curriculum, Matt, but if you're looking for some questions as you begin to examine your courses and your professional practice, these are some excellent ways to start thinking about what are we really conveying in terms of messages for our students. not just merely in our syllabi, but through all aspects of it. If we don't have, for example, a required clinical component to our programs, if you can graduate law school and never have contact in government or law firms, what message are you really sending to your law students about what matters in terms of their professional preparation? Catalyst for reform, right? Focus on the bottom here. I'm thinking about holistic and how to be more holistic in our preparation in our legal ed profession. And I'm drawing a connection here between the hidden curriculum, that is the entire socialization process of law school, and moving forward, and how we help students understand all of these bits and pieces, not in a hierarchy form, not what matters most, but how it all matters and how it all adds up at the end of the day to be a lawyer. No, huh? There we are. Couple of quick barriers. Thank you. Couple of quick barriers. When we think about curriculum, we often think of curriculum as an additive process. Sometimes we swap courses out, but it's usually we're just adding more and more, trying to keep up with trends in the profession. The second being that our assessments are often limited to individual courses, and they're rarely holistic in nature. Talking about, again, this idea that if legal preparation of the legal professions is holistic, then our assessment should be as well. So are there ways of looking at assessment that are not tied to individual courses, beyond individual courses, and really consistent with this idea of education as a socialization process? And so I throw out this idea of transdisciplinary as a way to think about, again, a lens as you engage in curriculum mapping to think of our program as a whole. Interdisciplinary, the difference being it's about putting all of the parts together. Transdisciplinary is very much about starting with the whole and then considering the individual parts. Enduring understanding, essential questions, these are sort of education speak for how we think about the whole. We ask big questions and we let the individual pieces and parts flow from them as opposed to trying to piece individual courses together, for example, to make the whole. A couple of more questions. How do we ensure that the sum of our program is greater than the individual parts? Again, that transdisciplinary approach. Sorry, this seems to be, right? A backwards approach, as I said. And then just as I finish, I wanted to share with you two quick slides which give you a sense of assessment as a whole. And I know you can read the individual pieces, and my expectation is what you couldn't. But this first slide is the beginning of the outline of our holistic assessment in my program back at the university. Number one is the education assessment plan. We actually assess what all of these other assessment plans should be. That's how much we focus on assessment. And then flipping to the next slide, and these numbers are a bit out of sequence here, but we've got nearly 50 assessments above and beyond individual courses that ask all sorts of questions about our students and their knowledge and their attitudes and our beliefs that we drew from our hidden curriculum to provide us data about how we move forward and prepare the best possible profession. It is a culture of assessment and a culture of accountability that's not imposed from us, but one that we're bringing upon ourselves. And then last slide was just going to be an argument about how it would be impossible for us to do our culture of assessment, which is tied back through our curriculum, which is cognizant of our hidden curriculum, without our partners. Our assessments are with our alumni, our assessments are with our schools, in the same way that they would be with your alumni and with your partners. So it's really a holistic look at what it is that we do to uncover all of the aspects and make the changes not from the pieces, but from the whole. And so that's, I know we'll have a chance to chat more about lunch and during breaks over this, but that's how I see things. Where are you from? Oh, Manhattan. the nice part.
Hi, I'm Glesner Funds, and I'm going to just first say thank you to all of you, and just pick up what we've just been talking about and put it through the lens of just one skill. And I'm going to tell you a little bit about why this particular skill. I'm from the sister University of Missouri institution down the road, University of Missouri, Kansas City. And about 5 years ago, we began our assessment process. And we started with surveys of alumni and research into what lawyers say they want, and what clients say they want. And we had several retreats that have become legendary for how difficult they were, and focus groups and all kinds of works. And we came up with 127 discrete learning outcomes that were, we thought, important across the entire curriculum for all law students. But of course, we couldn't assess 127 across the whole curriculum, 127 outcomes. So I put them all up on a wall, great big chart up on a wall, and give every faculty member 5 little stick-on stars. And I said, now, take your 5 stars and put them any way you want. You can put all 5 stars on one outcome, or you can divide them up. But we're going to see what people really care about in terms of these outcomes. And maybe find some of unpacking that hidden curriculum, kind of seeing what the Carnegie report talks about is the shadow curriculum maybe, and seeing what we really care about. And one of the things that came up was legal research. It got a lot of stars, I think. Maybe in part because Professor Collister, the director of our law library, put all 5 of his stars on legal research, but everybody else seemed to think legal research was an important outcome too. So there we go. Now we're off. Legal research is something we care about. And so we're going to begin the assessment of legal research instruction. And what I have learned from this process is a lot about the process of integrating skills into the curriculum, and some of the barriers and some of the ways that I think assessment can be an important tool. So, first question, if you're going to integrate skills, is do we care? Now, let's see, how many of you are law students? Would you raise your hand if you're a law student? Okay, so of the law students here, how many of you have spent some time doing legal research? Raise your hands, probably, high, okay. Let me ask, is there any law student who has not done any legal research whatsoever? Now, okay, all right, so it's something we all do. And let me ask, do you think that you could get through graduation? Could you get a JD without doing some legal research? Anybody think they could? No, okay, so we must care about it. We must think it's important. Of course it's important. McCrate said it was important. The ABA standards say it's important. Surveys of lawyers put it right up there at the top as an important skill. It must be important. And then what my work over the last couple of years has been, really? Is it really important? If you ask lawyers beyond their 3rd year of practice how much legal research they do, they'll say they do very little legal research. Surveys of private law librarians in the law firms say that more and more they're the ones being asked to do the legal research. So it may not even be a lawyering skill at all. It might be a law librarian skill. The legal research and writing curriculum, about which we've heard a whole lot as a skill, right, is a whole bunch of skills. And we talk about that R and L, R and W, but the R keeps kind of getting lower and lower case and, kind of becoming just a little fading superscript in that curriculum. If you look at the number of hours, the amount of time, who's teaching it, who teaches the legal bibliography exercises? Is it the TA? Is it the vendors with, highlighters and candy? Right? Okay, so do we really about legal research. So I think that's one thing, is that if we're going to incorporate legal skills throughout the curriculum, once we identify a skill that we think we care about, I think we have to step back and say, do we really? Do we really care about it? Because if we don't really care about it, then we're not going to make any changes. It won't really matter. Now, at UMKC, we require students to take, they have research instruction in the first year, but all students, and this is very typical in law schools, have an upper level writing requirement. And as you heard this morning, that even in your externship, right, they like write a legal research paper. That's typical process. So everybody has to do this academic paper. So what we did to assess this really and to kind of see how much instruction is actually happening is we took this legal research and writing requirement, which students can fulfill by being on law review or writing a competition brief or doing an independent study or all kinds of different. Everybody in the law school teaches legal research. Really? Well, everybody supervises one of these R&W papers. And so then I asked the faculty a question. How do you know if, you know what, I'm just going to skip the PowerPoint. I don't even know what's coming up next. And really is the question, okay? I asked the faculty, how do you know if the research that you're getting from your students in these papers, how do you know if it's any good? And the answers were very illuminating. Some faculty said, well, I only supervise papers in something that I know a whole lot about, and so I know what the research is, and I know what's good in it, so I know. Some said, well, I do a little spot checking, I do a little research. Others said, well, you know, I don't know. I look at the number of citations, I look for things that I expect would be out there, and that takes me back to thinking about lawyers. How do lawyers know whether the research that their librarians are giving them is good? What do we really know about this skill of legal research anyway? Now, if you go to the experts, the law librarians, and you ask them, they'll say, oh, well, process. They're very process-oriented. They'll say, well, did you develop a research plan? Did you really work the problem? Did you work a bit? The pedagogy of legal research, even by the experts, is terribly underdeveloped because we really haven't spent the time thinking real deeply about the skill and about what the skill components are and about whether or not we know whether that skill is being mastered or not. And that's what I'm learning. We have a research team right now that's taking an entire year's worth of these papers and is doing citation analysis to see, what are the students really citing and where are the gaps are. We're learning a tremendous amount about whether we really care about research and about how you really teach research. Really teach research, as opposed to, the bibliographic treasure hunts that have been the traditional stock of first year. See the students, they're like, yeah, well, yeah. It's like, and if there were only a pot of gold at the end, maybe it'd be worthwhile, right? This is a lesson for incorporating skills throughout the curriculum. So whether it's Clark, dealing with clients and communicating with clients, or whether it's alternative dispute resolution or mediation or whatever it might be, the first question we really have to ask is, do we care? And we have to use our scholarly research mind and skills to answer that question. And not just say, well, yeah, of course we care. Everybody has to know how to do legal research. Okay, so that was the why. Now, another thing that I learned at thinking about legal research is that some people care more than others. And this is Professor Moss's discussion about power and privilege in the academy, and is an important part of this discussion as well. Legal research has always been a part of the accreditation standards. It's been part of the curriculum till the mind of you know, mine not runs to the contrary, as they say. But it's kind of gotten smaller and smaller and smaller as part of the first year curriculum. And partly that's because the first year legal research and writing curriculum has been taken by the law schools and given to a set of faculty that the accreditation standards now have names for. We're not just faculty. We're tenured faculty who teach subject-specific doctrine in classrooms. And these other faculty call us doctrinal faculty or casebook faculty or stand-up faculty or other names that perhaps we wouldn't want to know. And then there are these, then I'm using ABA terms here, professional skills faculty. As though we here behind our casebooks don't know anything about that, don't have anything to do with it. Okay? So our professional skills faculty over here, and then there's this other name, they're legal writing faculty that are often called legal research and writing faculty, but if you look at where they spend their time, where they spend their work researching and writing, it's in legal writing. It's not, very few are experts in legal research or spend their time there. And then, not in the curriculum part of the standards, but over here, there's the librarians. Right? And who's the expert at teaching legal research? It's the librarians. Maybe. I mean, even the librarians are working right now on acknowledging that they're really not spending much time developing the expertise of their pedagogy and the whole Boulder Statement Project, which, if you Google it, you'll find it. See, that's another problem with research. We think we know how to do it. It's Google, right? Everybody assumes it's intuitive and it's easy, and we don't recognize that that skill over there is at the core of what the doctrinal professors are doing in their classes. That the core of legal research, the skill of legal research, is asking questions and finding answers. And that is all about legal analysis. That's all about, and the questions are way more important than the tools or the answers. Because without the right questions, you're never going to get to the right destinations or decide whether those destinations are good or not. So there's a lot of misunderstanding, and then there's a lot of ownership. And I think that's another second big lesson. How am I doing on time here? 2 minutes, okay. Another big lesson that I've learned is about ownership. That if only a small group of the faculty, and especially a group of the faculty who are, you know, over on the sidelines in power and prestige, if they're the only ones who either claim or are given ownership of a skill, then you can't expect that we're going to have integration. And that's the last thing I want to talk about, is this idea of integration. A lot of faculty, when they talk about integrating skills throughout the curriculum, what they talk about are interspersing some specialty courses. So add skill and stir, and it will all get integrated, right? Now, Judge Solomon spoke about integration in an entirely different way. He said, are the students integrating? Are they integrated? Students cannot integrate a skill. Skills will not be integrated if they are not truly integrated into the curriculum, not a special course. It's got to be, as Professor Moss was indicating, you've got to be able to look at a map and see that legal research is something that we care about across the whole of the curriculum. And we should. But why don't we? Why don't we integrate it? Well, one thing is coverage. Over here, we who hold power and prestige are concerned about coverage. And the law keeps growing and growing and growing, and we have to teach it all, and that's silly because the best educational research I've been able to find says that adding more content does not mean more learning. that the best way to get more learning is to have an iterative process where you come back and you go a little deeper and you learn it a little better and contextualized. That it's in the context of what it's going to look like for folks when they're actually applying it. So if you take that to legal research, I teach professional responsibility. It drives me nuts when attorneys call me and say, I'm out of time. And I say, it's okay, we got just a couple of minutes, we'll talk anyway. And they say, oh, you know, here's my ethical dilemma. And I said, well, have you looked at the rules? Well, no, but I talked to Charlie, and he said to call you. Right? They don't think professional responsibility is law. Well, what would be a great way to reinforce the message that professional responsibility is law? Have the students do a little research. What would be a great way to emphasize to students that any area of law is growing and developing and it's never static? Have them do a little research. What would be, you get the picture, right? There are lots of the curriculum goals that are really important to every single member of the faculty that research could be incorporating that little bit of skills experience into each class could reinforce other curriculum goals. It's not about them and us when it comes to integrating skills. It's got to be about us. And I'll just close with the us idea. Dean Wegner spoke about motivation. And intrinsic motivation requires autonomy, which faculty have an abundance of. And that's part of the problem. But it also requires shared purpose. It requires purpose. People want to feel like what they're doing is important. If we pick things we really care about and then look deeply to see how we care about them and whether we're assessing them and where we're incorporating them and who's claiming ownership of them, that can create a sense of shared purpose. And the third thing that really creates strong intrinsic motivation is a sense of mastery. And again, if we do this process, we say we care about research, we're going to assess research across the curriculum, we're going to make sure that when students graduate, they understand information. They understand how to find it, how to assess it, how to work it, how to know when to begin and where to begin, and how to know when to stop and where to stop. If we really did that and really assessed that, then we could prove student mastery. And that would help students feel great about their legal research skills as opposed to having won a treasure hunt, and could help them sell themselves to clients and to employers, and it could help us all feel like we're in it together as opposed to us and them. So I think assessment can be a great driver, but it all starts with one question. Thanks.
I certainly want to thank our panelists. I think that was fantastic. I feel sorry for my student who has a note next week due about their research. Be a little bit more critical now, figuring out what's going on. Questions?
I think this is the $50 million question. I would say still today, very few law schools have done major curricular change. There are a handful that have. So the question is to Judith, but then anybody else. So your first cornerstone, which you ended up with, Art, is that there has to be a real imperative that links to intrinsic motivation. You've looked around a lot. Schools that have really done meaningful change, can you give me some concrete examples of what the imperative is that is motivating them internally to make those changes?
I think right now it's the economy and the realization that they need to really have a way in which they're giving students the best chance. Really, it's an ethical proposition to be able to show that they have a level of mastery that they can either go on their own or worthy of employment. And that goes, the cycle really relates also to the fact that the accreditation process is there. That's well and good. I don't think that is what's driving it. I think right now, even more than the economy, it's the applicant pool. So why people come, whether they'll come, that we have to have something to say for ourselves, and that If it's just the same old, that's not going to do it. So I'd say the fact is these are external forces, but they have to be turned into something internal that we really care about these students, that we're not going to be able to sustain ourselves as an effective institution without drawing good students, and if we don't really give them some mastery, they're not going to be employed. I don't know what others would say, but I think, though, that comes down to conscience. I'm making a distinction here. Those are external forces, but they have to be experienced and felt at the institution level, most likely.
An observation, if being worried about your graduates having decent employment or being worried about attracting good students is the imperative, it sounds to me like the schools at the top of the food chain are the ones least likely to change that, because they're still not worried about getting students their jobs.
Except for the fact that I think there's a strata there that they're competing against each other for the best, and that part of that is insofar as students are smart and are asking, if I'm going to go into this level of debt, who's giving me the best result? I think that's its own little tournament. And at some level that can be intrinsic for them because they want to be number one, whatever framing you take that. Others want to comment?
There's an interesting learning theory called conceptual change. I don't know if you're familiar with the notion. I'll save you the lookup of the reference. Here's the beginning and end of it. People don't change unless they're dissatisfied with something about their own look, behavior, actions, learning. And so the $51 million question is, in what ways, are law schools dissatisfied with what they're doing? And I think that's an interesting observation, that if you're not dissatisfied, if you're ranked number 6, and you've got 100% placement, genuinely 100% placement, rehiring grads or whatnot, what is the motivation to change? But are we at a time now where the external pressures will actually cause schools at all levels to be dissatisfied because their graduates will not be as relevant?
It's interesting because we're all excited that there was stuff in the New York Times about NYU changed its 3rd year. So we get all excited because we think real change has to happen at the top 20 schools, and yet,
I would just add that, Stanford, Harvard, some very top-ranked schools have made significant changes. Maybe they're not requiring it for all students, although Harvard is on the problem side. And I think some of that is that we, whether it's from the reports criticizing legal education or other factors, we're getting much more aware of other disciplines and how they learn and how their students are better prepared. So I think the best, when I spoke at Harvard, the best speaker was the dean of the medical school, who set out a problem-solving vision for medical students. And it was far and above what we're doing in law schools. So I would just say there's some maybe other forces working at the elite levels.
If I can ask a question, so far today, everyone has presumed that the first year should remain the same, that we should engage in Socratic Method, or at least that's been the general sentiment. And it seems that teaches to one type of learner, and that gives that learner a distinct advantage going into years 2 and 3 with respect to job prospects and law review, and if their grades are too low, may be excluded from practical learning skills. And so in effect, it seems as though with this tethering of tradition, this notion of Socratic Method, that we want to keep this, and the one exam, pedagogically unsound. I think anyone would say one exam at the end is pedagogically unsound, and yet no one's talked about changing some of those very fundamental building blocks of those core fundamental courses. And so my thing is, how does that play in if in effect we're saying we want practical learning, but leave the first year unchanged? We'll change 2 and 3, but students maybe at the bottom are still going to be disadvantaged in years 2 and 3.
Yeah, and this is what really comes back to this really question. When you ask about schools that are doing real curriculum change, and NYU's changed curriculum, Stanford's changed its curriculum, and this goes back to your comment, that the curriculum, the real curriculum, isn't cataloged. Mm-hmm. The real curriculum is what's going on in the student learning, the nature of student learning. And
through the experience.
Yeah.
In total. That's right. Yeah.
And so I think that we have no idea where real curriculum reform is taking place, because we have no idea how many law schools in their first year are incorporating midterms and minute papers and little quizzes and some formative assessment and, you know, things to change the nature of that learning, the prerequisites for these. We haven't the foggiest idea unless we care enough to really, really, really ask what's going on in the classroom. The ABA curriculum study is a great start, but it doesn't tell us anything about what's actually going on inside the classrooms and the clinics and stuff.
It would be an interesting research project to look at what I think intuitively would be a huge causal factor, which is to look at law schools where people who do clinical teaching are members of the tenure track faculty. I actually think that, talk about power and privilege, law schools where people who do clinical teaching are part of the tenure track faculty are far more likely to change. And I think that's because the people who do clinical teaching become people who get to put stickers on pieces of paper on the wall. And as long as we have what you described with the librarians totally disenfranchised, research and writing instructors mostly disenfranchised, clinical teachers substantially disenfranchised, if you look at that structure of law school, that has a big correlation with what their imperatives are and how they change.
See, at the risk
that's just that's a totally different thing than looking at the catalog.
But at the risk of sounding too fringe, I think that's only a way station. I think ultimately you want to be able to look at the faculty and have a hard time distinguishing who is teaching clinical and who is.
Exactly.
Yeah, that's the goal.
Exactly, and there are schools that are like that.
I would say that was the last question, but I can't deny Judge the opportunity for me to ask a question. So,
and you're good. We can go on for a couple more minutes.
Okay.
If people want to stick around, this is really good. So we can.
All right.
Yeah, I don't think, at least the suggestion by most of us, is that you should do nothing for the first year. I think the notion was that you continue to teach subject matters that require kind of doctrinal analysis, but not necessarily that you don't inculcate some of these other values that we're talking about. So even in teaching those courses, you may be able to work in lessons about professionalism or also lessons about skills. I think there was a suggestion best practices to move away from such reliance on the Socratic Method. That should not be the only method of teaching doctrine. So I think the idea is that you still need rigorous analysis, that the first year is a time when you kind of inculcate students with certain approach to law. But I don't think the notion is that you just leave it packed and you do nothing with it. At least that's my view.
Well, I think my critique is more about the testing methodology.
I would, just a couple points on that. I would say if we really move toward learning outcomes, the curve is going to have to be put to the side because if what you want to do is to see where they're at, that is not in any way translatable to the curve. It may be that if you use absolute benchmarks, you can show people where they are and help them develop more expertise, but that's going to be a challenge because we've done it historically. It really is replicated privilege and all that stuff. So those who really work on that, I think, are going to be in the forefront. In terms of change in the first year curriculum, I think a lot of schools, there really wasn't time to go into this, but there really has in many places been expansion of legal writing and research so that it's a lawyering course, in some places extended to the second year and including things like interviewing counseling and things of that sort. How that's assessed, is that going to be graded in the same grading protocol? I think that's another point into the assessment change that you're looking for, because to me, it doesn't make sense to be graded comparatively in those areas when you can really develop rubrics and have something that's more fundamental. So I think you're right on assessment being critical, but I do think there's more change as people realize that, and I'd echo what Barb said.
Tons of research on rubrics and how effective they are at actually promoting the kind of learning that we want to promote, as opposed to these single end of term assessments. Great quote about that, right? It goes something like, you know, the autopsy has never helped that patient make healthy life choices, right?
Yep.
It's true.
Well, that's in one of the most exciting products of our ongoing little project on improving legal research instruction at UMKC is we took that survey from the faculty about how do you know whether people are researching well, and we turned it into a rubric. And then we asked the faculty to anonymously, so that they could admit that they were giving students credit for papers that were researched really badly. We had them submit, every time they turn in a paper from a student, say this fulfills the R&W, they would check off this rubric of legal research. And so we have a whole bunch of faculty's assessments of their student research. But what we found was, of course, faculty are embarrassed when they have that rubric to say, oh, I'm going to give credit to this paper even though, oh, balancing research sources. Actually, no, it was all from one side. Or, you know, appropriate balance between primary and secondary authority. Oh, actually, no, it was a book report from a series of law reviews. You know, they were embarrassed. And so they wouldn't turn the papers in for credit to the poor students. Then the students got it back and said, you know, you can't just write a book report about law reviews. And the rubric is driving the teaching in an improved way. It's really a remarkable kind of, as Mr. Phillips was saying, a sneaky way.
I just have a quick question. In the interest of full disclosure, I am an adjunct faculty, but I know in this economy, in this economy, I know a lot of schools are looking more to adjunct faculty because we are cheaper on the whole. I mean, we can have 4 adjunct faculty teaching for less than 1 full-time faculty.
Oh yeah, you see, I didn't even put you in the room, did I?
But what I want to know is, in a good law school curriculum, what is the proper role of an adjunct? I mean, is an adjunct supposed to be teaching core classes? Is an adjunct supposed to be teaching upper-level specialty classes, skills classes, doctrinal classes? What is the proper role of an adjunct?
That's a great question.
And it's interesting that it wasn't on our agenda.
I'll take a stab at that. I think it varies from school to school. In a lot of places, people look to people from practice as having sophisticated expertise for advanced offerings, for skills-type courses, say trial advocacy or something like that. People who have lived that skill set can bring it to bear. I think a lot of advice I would give would be not to have adjuncts teaching doctrinal traditional courses because it's harder to have them be accessible to the students. One of the reasons we changed to full-time legal writing people from a more adjunct-oriented model was we had originally thought that having adjuncts with writing problems for the first-year students tied to their expertise would be valuable because they had genuine writing expertise that students would see as relevant and augment the kind of academic training would be given. But to have the time, even if somebody takes on that kind of role, the students would have to drive to catch up with them or things like that, so that seemed to be less advisable if it's a basic first-year kind of course or a doctrinal course where it's harder to be available to the students.
In terms of like the holistic picture, the discussion hasn't yet touched on touched on how professors mirror behaviors that we want the students to develop in school. And so the idea of you teach your student as if you were the client to get them to talk to you as they would the clients. And I'd love to hear some more about your thinking around that issue.
I think it would be a small but rather radical step to actually have clients in the classroom. We have in our first year Introduction to Law, Legal Research and Writing course, In the second semester, one of the sections students can elect into if they're especially interested in our family law emphasis. And one of the things that we started doing is no matter what problem they're working on, whatever the big brief problem is, that it's a fairly traditional program, but one of the innovations was we brought in some clients, some people who had been clients in that kind of problem. And it was one of those incidental conversation kind of, oh, I represent, you know, actually it was I had represented a same-sex parent in a two-parent adoption case, and that was the brief problem. And I said, you know, the client I represented was so grateful. She said, I'll talk to your students anytime. Would you like her to come in and talk to the class? The difference, that half-hour conversation with a real client about what their experience had been like going through a real case like that, made for the students. On the oral arguments that year, we saw the best oral arguments that we'd ever seen because they had that context of, oh my God, this isn't going to be for a grade in legal writing, this is going to be for a real client whose child's, you know, future is going to depend on this. Made a huge difference. So we've tried to incorporate that every year now. And so I think that's one idea for something simple.
I've got another thing that I do in a number of my classes, which I think works really well, which is to have students play clients and to reflect on what the experience of being a client is and what they learned. I teach a negotiation class yesterday. The students were playing lawyers. We're doing one activity, and I was talking with the students who were playing clients, and it was just incredibly rich about what they observed in their role as being a client. So that's one other possibility.
You know, I've got a problem that you can download from SSRN that you can use for students to be clients. And I think it works really well because the client is a student who got denied admission to the bar. And so the problem I always have with students playing clients is that they don't have the life experience of the clients, right? You know, so you ask them to play whatever, and you know, a construction contractor, and they don't know the difference between a claw hammer and a ball peen hammer, and so they can't do it. But they've all been law students, and they all understand the bar exam, and so if you put them in the role of being an applicant to the bar exam, boy, empathy comes really easy in that setting. So it's
actually a little bit more submerged question, which was the faculty represent what the student aspires to. These are the lawyers they're teaching. And that's why I'm specifically interested in Professor Cunningham's example, to get that conversation going. Because the idea, in order to give good advice and thoughtful advice and good counsel, is to be able to talk to the clients and empathize. What's the reflection as far as that and the teaching process? The modeling of that behavior.
Not quite an answer, but my favorite quote from Educating Lawyers was, you know, they interviewed law students. And a law student said, law school seems to be about making people smart without a purpose. And part of the hidden curriculum. You know, so what are we as law professors communicating to students about what's the purpose of being a lawyer? Which has got to be different than bringing in a judge to give a speech on professionalism and orientation, which is, you know, then we're done. And part of my feeling is to the extent to which we're communicating what's the purpose of being a lawyer, by the way we teach, what we communicate is the purpose of a lawyer is to win the courtroom battle. And that just has a real powerful effect. And that's not the only purpose of the lawyer, even if you're living. So I don't think that's a helpful response or not.
Well, I mean, I get that part.
Yeah.
Should we be doing that? And if we shouldn't be doing just that, who's thinking about how that should change and what kind of changes are being made?
I'm not sure if I fully grasped the nut of the question, but I think generally we have to be more cognizant that we are lawyers, the first model students are seeing. So, for example, I teach first year property, and I try to talk to them intensively about how you would develop facts, what is the story with this client. I bring in people from our Civil Rights Center who are leading students to go out and do wills projects over break, where they're going to have a chance to advise typically poorer clients with farmland about how to do estate planning so the land doesn't get all chopped up and lost to the family. And then I may bring back that topic after some of them have themselves gone out and done that pro bono project, and have them talk with each other in the class about what they got from that, so that it's reinforcing that they are being lawyers already as a starting point, that I am a lawyer because I engage with my colleague and he's the managing lawyer, so he talks about what the Center for Civil Rights has actually been doing, and that typically kind of triangulates the issue by having me say I'm seeing myself as a lawyer, having my colleague do that, and then have the students themselves realize that they are lawyers insofar as they actually are talking to clients. I don't know if that hit where you were going, but that's just, I think, within each person's sense of self and their recognition that when they're on the podium, they really need to be thinking of themselves consciously as a role model, how they will bring in examples of their own work and that kind of thing. I think if that's all bleached out, so that's not there, then nonetheless they're getting an impression that we ignore all the rest of that, which is not what I think they should be getting.
And I'm sorry, this is the last question I have later from John.
I do think we are the most litigious society in the world, and maybe one of the most violent cultures as well, and that the legal profession has historically been aimed at litigating and at resolving in courtroom. And I think that nationally, lawyers are now leading towards civility as opposed to violence. And I think they're also understanding that to be in a global society, you have to solve problems, not always litigate. Other cultures sometimes, particularly in Asia, value peace more than many. And we have to acclimate to that it isn't always about winning. And I think that law schools need to grasp that we're global now, not just the way it's always been in American culture.
With that, I think we should thank our panel for the last time.